Good evening, everyone. It is Tuesday, May 13th at just over 8:30 p.m. Eastern Time. And I wanted to talk about what's been happening in my Florida Circuit 7 family law case the last week and a half. We are actually going to be exposing some more emails we got through Freedom of Information Act with the Volusia County Sheriff's Office. So that has been merged into my motion for disqualification of my judge. So last thing we did was May 2nd, and that was our hearing, right?
I think so.
So we discussed that a little bit last time, where it was a 30-minute time for the hearing regarding my motion to vacate the general magistrate's recommendations. So the hearing sheet, so this is everything that's been in my docket since that occurred. So the hearing sheet, for 30 minutes of me speaking, I literally spoke the whole 30 minutes, right?
Pretty much. I mean, Justin spoke for maybe like 4 minutes.
Yeah. So what does this say occurred in that 30-minute hearing?
Everybody was present. Petitioner addressed the court, reads written statement. Respondent addresses court at 9:22, and then 9:29 the petitioner rebuttal, and then court finds CA to take under advisement. So they use a lot of abbreviations on these. So it's the court to take under advisement. Court recesses at 9:34. So it opened at 9 o'clock, ended 9:34.
And that's it.
Those are the only notes.
This has been a very common theme in my hearings in Florida Circuit 7, where the hearing sheets have absolutely nothing on them. So here's the front page, and like always, all of this will be scanned, and you guys can see these documents in my YouTube in the link. But that's the hearing sheet, cover sheet, and then the next page is the handwritten notes.
It's really just a timeline of the actual hearing itself.
So that's it. In 30 minutes, this is all that was written on these hearings.
So there was no notes recorded on what the actual testimony was.
Yeah. So that is a very common theme and a tactic they do, because if nothing is documented, you have no ground to stand on. So they intentionally do not document anything to screw you over as a citizen. And then on May 6th, so last week, we finally got the order on motion to vacate. That was denied. So it was that rubber stamp denied. And Pete, do you see an explanation of that denial anywhere? A legal explanation as to why she denied it?
No.
No. She never. Between Stasia Warren and Sandra Upchurch, neither of them ever give explanations for the denial. Just denied. Be gone with you. So that is DIN 166. So here we are. We're at document identification number 166, and I'm still no closer to seeing my children. So because of that, and then something else that I had been working on and waiting for a response on, I then filed.
We got what you've been waiting on. We got the response a week ago. Mm-hmm. So it sort of has taken a week to sort of go through the material and digest it and have an understanding of what it was we actually received.
Yeah. So what we were waiting on was a Freedom of Information Act that I had pulled pretty much right after the Volusia County Sheriff's Office showed up at our house and dragged me out of my house in handcuffs without even having shoes on, all for $1,000. Hey, L, see you there. All for the $1,000 purge for the child support that was signed illegally by Judge Stasia Warren November of last year. So that whole thing finally came to a head when all of a sudden I have sheriffs showing up at our door to arrest me on this $1,000 purge. And that was actually my very first Facebook Live I went on. Back when that occurred, I went live right after that happened. So you guys got to see in real time the effects of this domestic violence and harassment and abuse of our judicial system by Justin Serlick, basically using law enforcement to harass me and try to get me to just disappear, and that's not going to happen. So rather than going and hiding after they attempted to arrest me, I turned this camera on and I went right in front of all you guys. In that one video, I mentioned that the officers, when they had me in handcuffs, made a comment multiple times.
It was clear, because by this point I had gotten home. It was clear when the deputies that were here were trying to explain to us what happened that they didn't want to be there. They gave us the impression that even they knew something was out of the norm with this situation. And so once we got Heather out of the patrol car, Heather turned on her recorder to ask the deputy a couple questions, and the deputy said something, which is what triggered us to file this information request.
Yeah. So Deputy Moser said to me, someone emailed, well, one deputy said someone called the sheriff, and the sheriff would be Sheriff Michael Chitwood of Volusia County Sheriff's Office. He's an elected official. The one said someone called the sheriff and shit rolls downhill. The other one, Deputy Moser, on camera, and that video recording is on my YouTube, said someone emailed the sheriff and shit rolls downhill. So between two of them and getting two different responses as to how they ended up at my address, I knew something was not right. So I immediately went on the Volusia County Sheriff's Office, went to the public records section, and requested a Freedom of Information Act. And what I did was I put in that portal, I want any and all communications, email, text, etc., from the very beginning, so like the last 3 or 4 years. I want you to search your records for the last 3 or 4 years for any communications that have my name, Heather Bendl, mentioned in those communications. And boy, did we get some results. So I had to pay $40 for the labor that it took for them to go through the records and put it all together. And then I was emailed 70 records, 70. Quite a bit of it I already knew about, but...
and some of it was not law enforcement related. Some of it was, jobs Heather's applied to with Volusia County.
Yep, because I have actually interviewed for positions at the Volusia County Sheriff's Office, so it even pulled like my interview list. The day I went in for the interview. There was
a record when Heather spoke at the school board meeting, because apparently there's a record there.
Because the Volusia County Sheriff's Office is at the school board meeting. So so when I got up and spoke at the school board meeting January 14th, that actually came in as a record as well, showing exactly what I spoke about. So I thought that was kind of cool. But what we did get, so Pete, tell everyone what this is.
So there were in the 70 different records, there were several emails.
Yeah. So this is just payment confirmation.
So this is just Heather, confirming that she paid for the records request. Okay.
And then this, let's keep this in order. This is just a confirmation that my records request is complete and it's available in the portal. FOIA is more for federal and more limited. Okay.
So Heather will reference it as FOIA.
Yeah, I call it free. It's
basically filing a public information request.
Yeah, FOIA, public records request. It's interchangeable.
Here in the state of Florida, it is probably one of the most open public record states.
Yeah. Illinois is very closed to these types of documents for a reason, because they're trying to hide.
Here in Florida,
illegal activity.
The documents exist, there is a way to get them. Unfortunately, generally you do have to pay for them because you have to pay the labor. It takes one of the employees to actually perform the search and print everything and then get it scanned and sent to you.
So some of the police departments, I think even Daytona Beach Police Department, when you go to the public records section, it actually says FOIA as well. Yeah. So the acronym is interchangeable, but it just means public records. So we got, what day was it last week? Tuesday?
It was Tuesday.
It was last Tuesday we got these documents, and did it upset me. I'm going to have Pete read to you the emails and explain who they're from and who they're to. But Pete, I want you to start from the beginning of this email because it's backwards because it's most frequent. But I want you to start at this part.
Okay. So again, we had a belief that somebody interjected themselves into Heather's situation to get the sheriff's office involved, and we were right. You can't make this stuff up, but it's the same two people that Heather has pointed out numerous times, and they just, aside from the blatant lies in there, we'll let you guys
so start
decide.
From the and just kind of read down.
This was an email from the email address imserlick@gmail.com, which we know is the email address that Mary and Ira Serlick jointly use. This was sent Thursday, March 20th, 2025, so this year, sent to Sheriff Michael Chitwood of the Volusia County Sheriff's Office. Subject, tip for easy arrest of Heather Louise Bendl on April 19th, 2025 in Deltona. So, just to remind everybody, April 19th, what day was that?
That was Easter weekend.
So,
where I was to perform in the Easter choir at Trinity Church on Good Friday, the 18th. Okay. And then we had Egg Hunt on the 19th, and then Easter Sunday church.
Okay. But the key point is the date this was sent, Thursday, March 20th. So remember that date. Dear Sheriff Chitwood, Volusia County Sheriff has an order for bodily attachment, aka arrest warrant for Heather Louise Bendl of Edgewater. I realize that with spring break, bike week, your officers are busy. Here's a tip posted by Miss Bendl herself on her Facebook. And then in parentheses, narcissist. Please feel free to pick this deadbeat mom up at her church. Let me read that again. Please feel free to pick this deadbeat mom up at her church. She is basically under the assumption that she cannot be arrested in Florida. She is a newly converted to religion con artist. I have known her for 22 long years. She is a devout atheist from Illinois, ex-daughter-in-law in parentheses. Also a known stalker, cyber stalker. Please have her. Now, it's pot calling the kettle black. Known stalker / cyber stalker. But with this email, there was also screen captures of Heather's Facebook page. So who's stalking who? You decide. All right, please have her picked up at her church. Again, that's the second time in the same email telling them to pick her up at church. Make sure your women officer is present. Also, she is deaf in one ear and she will play on that. Yes, it is a fact. Heather is deaf in one ear. Yes, it is a fact. It affects her communication. It is what it is.
And then attached to that email to Sheriff Chitwood.
Screenshot of the Facebook post and screenshots of a yard sign we had in our front yard for Easter.
You can't really see it because it's a reprint, but Trinity Church handed out yard signs advertising Good Friday performance, 7 p.m., and then Sunday and everything. And then it's signed, please know I appreciate all your men and women in blue. Do for Volusia County. Best regards, Mary Serlick, resident of Port Orange. Sheriff, your men wear green, so you should go out and get her for calling you guys blue. Just saying. Yeah. So it's very telling when a human emails the sheriff and directs them to arrest another human at church. No. No real Christian, like myself. I have read the Bible twice. I was raised Roman Catholic by my stepfather's family. I was chosen Baptist. I went to Sunday school my entire childhood. I went to youth group every Thursday night, reading the Bible. Mary Serlick, what was your son doing on Thursday nights when we were in high school? Playing video games with his best friend.
Okay.
I went to church in high school and middle school. So it's very telling when someone, how did you get that email? I missed that part. Yeah, so this was a public records request that I did with the Volusia County Sheriff's Office. And we got these emails provided through the public records request.
So these were emails that other party that should not be involved in this
Mary
case.
Serlick, Justin Serlick's mother, emailed the sheriff's office telling them to pick me up on a writ of bodily attachment for the $1,000 purge.
But that was not the only email. There was also an email from Laura Stiles.
Laura Stiles.
The email from Laura Stiles, no subject on this one. Or, I'm sorry, the subject
there is.
Note to Mike Chitwood.
Note to Mike Chitwood.
Like they're best friends.
They're all buddy.
Hi. Message reads, we'd like to see the arrest of Heather Bendl, who owes an amazing $32,000 in back child support. It happened today. She has filed to run for 2 state offices. We want the people to see she is lying about who she is. She's a child abuser, plain and simple. Volusia County courts are not corrupt by denying her access to or her motions to her abused children. So a couple things about this. First of all, this Laura Stiles legitimately has zero business being involved in this case at all. Heather's discussed her before, so I'm not going to discuss her anymore. What I do want to address is some of the blatant lies here. So first of all, the amount of $32,000 is not all child support. Nope. Half of that was attorney's fees. And here's the thing, it's
Justin ordered me to pay his attorney fees.
Slow down. So, well, as the court ordered it, but here's the thing, the case is currently in appellate court. So all of that can get reversed. And if the appellate court actually follows the law and the rules following the UCCJEA.
And what is the law?
So the UCCJEA basically says the court that has it's a whole statute on how to determine jurisdiction in juvenile cases.
If you Google UCCJEA, 49 of the 50 states have adopted it. And the only state that does not take part in it is Massachusetts.
And it basically says wherever the child was 6 months prior to the initiation of an action, that is where the child's home state is, and that's the state that has jurisdiction. In Heather's case, the kids were in Florida for more than 6 months before the court in Illinois made the custodial determination. So
I have
Illinois
an email.
Should not have made that decision.
I have an email from Elizabeth Tevis of Camelot Care emailing my attorney, Thomas Hunter, August 13th, 2021. Sorry, I already dropped off the children in Port Orange, Florida this morning, so Heather's not going to be able to see her children before I take them down here. So I have an email confirming the exact date and time they were dropped off at Mary and Ira's in Port Orange.
The kids had been in Florida for more than 8 months when the Illinois court made the order. So then the other point of fact I want to get to in here, this email claims that Heather is a child abuser, plain and simple. Heather has absolutely 100% never been charged with child abuse. Nope. In fact, the original allegations there was no child abuse in the original allegations.
The abuse word keeps getting mentioned by Mary Serlick and Laura Stiles.
We have the full
nothing official.
We have the full Illinois DCFS investigative report that was turned over to Heather's attorney, and you can certainly see they tried to come up with stuff. They couldn't. But there was no allegations of abuse, and ultimately Heather was never charged with anything. There was never any, even for what did transpire in that case, in the juvenile case in Illinois, there was never any evidence presented Basically, they just went off of what Heather's ex-husband, Justin Serlick, said, claiming that Heather had mental health illness issues, and that's what they ran with.
Yep.
And that's ultimately the only thing that the juvenile court in Illinois determined, and they did that without any evidence. So
yeah. So that's just Chitwood forwarding Laura's email to Eric Dietrich.
Yeah. So there was basically those were the two outside emails that came in to the sheriff's office, and then there were several emails between different sheriff's deputies and command staff about the case. Ultimately, there was a reply from a Lieutenant Maxwell to Laura Stiles. Good evening. Heather Bendl was detained yesterday around 3:30 and paid the purge. So just pretty much straightforward.
And you guys can watch the video right after that happened, so you can see just how
and then,
emotional I was.
Of course, Laura responded with, "Thank you."
Thank you. And that's just, them proving that 2 days later they still didn't have it.
So, now, remember the date. So the very first email there from Mary Serlick was on March 20th. So on March 20th, Mary Serlick somehow had the knowledge that there was a writ of bodily attachment signed. On the 21st, the next day, Laura Stiles knew about it. The deputy showed up here on was it the 22nd when they showed up?
Yeah.
Here?
Yeah.
And then on Monday, March 24th, so they showed up here on a Friday,
yep.
And then so it was the 21st when they showed up. And then on Monday, March 24th, we have a email from Joyce Walker, civil enforceable clerks. Subject, I'm looking for the original writ of bodily attachment for Heather Bendl. I have a folder that was given to Rob, but not the original.
They didn't even have the original. So here's the thing.
So
nobody had the original. And how do I know this? Because it should be in my docket. It should absolutely be in my docket. Now, how do I know the exact date that this writ of bodily attachment was signed? Because I was sitting in the back of the squad car with handcuffs behind my back, and I'm staring at the laptop that Deputy Moser is typing on as he's collecting the payment from Pete. And it's a writ of bodily attachment signed by Sandra C. Upchurch on February 19th. February 19th. So, if she signed a writ of bodily attachment on February 19th, I had a hearing with Alexander Alvarez February 25th. It was never mentioned then. It was never filed into my docket. So how?
It's almost like it didn't exist until they send the sheriff's deputies out.
Yeah.
I mean, there was a purge amount on a court order. Mm-hmm. That is true. There was. But the sheriff's office didn't have the documents when they showed up here.
Right.
Apparently, the civil enforcement clerks didn't even have the documents.
Nope.
So somebody's doing sketchy stuff at the courthouse.
Yeah.
And
so
that gets to the next email.
Here's the thing, though, guys. How does Mary Serlick and
technical issues.
Sorry about that, guys. Facebook kicked me off live.
We'll stitch the videos together, but ultimately what we were talking about
was how Mary Serlick and Laura Stiles...
Couple minutes for other people to reconnect?
It's fine.
Okay.
So what we were discussing was how Mary Serlick and Laura Stiles knew about this writ of bodily attachment, even though it was not in my docket. It was not mailed to me. It didn't exist. So how did they know it even existed?
Well, that's an interesting question.
Yeah.
And we have a couple theories. Mm-hmm. One we have some evidence behind. So a couple things to know. Mary Serlick's husband, Ira Serlick, he is a volunteer in police service with the Port Orange Police Department.
VIPS.
Whether or not he has access to databases and systems where he can look information up, we don't know. But just to be on the safe side, what did we do? We did, Heather did send an email to the chief of police just to at least, ask him the question, does Ira have access to stuff? The response Heather got back was no, he does not. However,
Three more people
were added onto the email chain. So it was almost like a CYA that they're going to be doing some double checking.
Yeah.
Now, what we do have evidence of is that Laura has connections at the courthouse. And this is, I know we've talked about this email before, but this was an email that Laura sent directly to Heather back on February 24th. And I'm not going to read the whole thing.
Yeah, we had actually read this email and the whole video about who is Mary Serlick and Laura Stiles. So this email has been read before.
All right, just the last sort of line here. And your screaming match at the courthouse last Friday is going to make you any progress? ? You don't think judges don't hear about that behavior? Just stop. Just go away. Quit screwing with everybody with your pitiful cries for attention and just go away. A lot to digest there. Like I said, I didn't read the whole email, but what the email is referencing.
How did she know it was there?
Heather was in the clerk of the court's office to file some documents in her case, and Heather made it known to the clerk staff that we knew somebody was sharing information.
Oh, yes, I did.
And proof's in the email.
Yep.
So we know it happened. Now, here's the thing. Heather knows exactly who she talked to.
I have names.
At some point, probably sooner than later, we're going to be having a conversation with the state attorney's office because that is, definitely concerning behavior as a citizen of Volusia County. Very concerning behavior to know that people in the courthouse are just sharing information with random people.
Yeah.
That are not part of cases.
Minor children.
And this is what, they're sharing information about Heather's case. Who's to say they're not sharing other information? Who's to say they're not sharing personal information?
Exactly.
If they're freely willing to just, share other, information, they're more than likely they're sharing other stuff.
Florida Circuit 7 Daytona Courthouse staff absolutely needs to be investigated because there's no way they're doing this to just me. There's no way. I'm not that special.
The other emails we got as part of this were just sort of from different sheriff's deputies back and forth,
emailing each other
just
back and
documenting
forth.
That they got the tip. They conducted surveillance at the house. They saw Heather's van parked in front.
Yeah, so let me read this one.
It's not like we were hiding anything like that.
This is Eric to Sheriff Chitwood, Eric Dietrich, whoever that is. Sheriff, surveillance was previously conducted at 1709 Queen Palm Drive, Edgewater, for Heather Bendl. Her primary residence is in Volusia County. This is a good address, but the residence has use of ring camera system. Yeah.
Who doesn't have cameras in front now?
We had to set up cameras for his mother when she was still living here because she had dementia and we needed to keep tabs on her at all times. So it's interesting that in the body cam footage I got with my public records request, because I pulled the body cam footage of both the deputies that were here and pulled me out of the house that day. As the one deputy is sneaking through our neighbor's yard, through the side of our yard, which is on the body cam, he literally radios, you can hear him radio, we've got body cam or ring cameras everywhere on the residence. What are you doing? A sting operation?
Let me point out what we actually have.
If you're not doing anything wrong, it shouldn't matter if there's ring cameras.
Yeah, and we have what it is. We have a Ring doorbell. A lot of people have Ring doorbells, and we have a couple other cameras just to cover the yard and watch our vehicles in the driveway.
So they're literally writing this like it's a problem that I have ring cameras.
We also have cameras in the backyard and we have cameras in the public areas inside the house.
Senior Deputy Robert Hansard is assigned this case and has made recent attempts to locate Bendl. Today, her vehicle was observed at the primary residence and two of our civil deputies will be attempting to take her into custody. She has a purge of $1,095 and it is for delinquent child support. Okay. So that leads me to the next point in my case. So what do you guys think I did with this information?
So now, if, there's really one of three ways that Mary and Laura got the information about the writ of bodily attachment. Either Ira's abusing his power and position as a volunteer with Port Orange Police Department and got it that way. Laura, Mary's best friend, is abusing, clerks are abusing their position and sharing information with somebody who's not party to the case.
Someone is abusing something at their job. Someone is. Or
the judge or her JA shared the information directly. Mm-hmm. You decide.
Yeah. So that leads me to the next thing. I filed into my family court case May 8th, DIN 167, and that is Petitioner's verified motion for disqualification of Judge Sandra C. Upchurch. Yep, I filed a motion to disqualify this judge that keeps rubber stamping a denial on every single one of my things for many reasons, actually, but these emails are part of it. Petitioner introduction. So I took some time writing this up. I used a few of my resources. I had a friend of mine help me with this, move some things around. Beth, thank you for your help again. If any of you are needing assistance with doing your court documents, DM me and I will get you in connection with Beth. She is helping others in this family court corruption insanity. But introduction, petitioner has become aware of numerous interactions suggesting a personal connection between Judge Sandra C. Upchurch and members of the respondent Justin Serlick's family and friends, which jeopardizes the impartiality required in judicial proceedings. 2, petitioner respectfully moves that Judge Sandra C. Upchurch be disqualified from presiding over this matter due to her direct personal connection with respondent Justin Serlick's family. This relationship raises serious concerns regarding the judge's ability to be fair, impartial, and to preserve the integrity of the judicial process. And she cannot rule on anything until she rules on that. Yep. Well, it's been sitting since last week. It's just sitting. The grounds for this motion are based on specific factual allegations, which, if proven, create a well-rounded fear that petitioner will not receive a fair hearing. Accordingly, petitioner submits that Judge Upchurch must recuse herself pursuant to her ethical obligations under the Florida Code of Judicial Conduct, Canon 3E, which requires judges to avoid even the appearance of bias or prejudice. Well, she's already screwed at the appearance because Mary, Ira, and Laura Stiles waved at her after the hearing. Why would you wave to a judge you don't know? And then factual allegations. Firstly, it has come to light that Judge Upchurch has engaged in social, familial, or business interactions with members of the Serlick family and friends including Laura Stiles, outside the scope of this legal proceeding. Such interactions create an undeniable appearance of a conflict of interest, raising questions about her ability to remain neutral. I wonder if I ever waved goodbye to her on her way out. Yeah, Dana, all 3 of them waved goodbye, like they were all friends with the judge. Number 5, further specific incidents underscore this concern. Judge Upchurch has consistently denied every motion filed by petitioner Heather Bendl without providing valid legal justifications. This pattern of ruling indicates a possible predisposition against the petitioner, potentially influenced by her relationship with the Serlick family and associates. Mm-hmm. Dana did hashtag witness because she was at this hearing, so she witnessed them wave. 6, additionally, on March 20th, 2025, emails from Mary Serlick and Laura Stiles to Sheriff Michael Chitwood instructed the arrest of Heather Bendl at Trinity Church on a basis of a writ of bodily attachment signed by Judge Upchurch. And then I submitted all these emails, Exhibit A, B, C. Notably, this writ was never filed into Heather Bendl's docket nor communicated to her, yet was known by Mary Serlick and Laura Stiles, Exhibit A. Judge Sandra C. Upchurch signed this writ February 19th, 2025 for the purge amount of $10.95, Exhibit A. This purge was part of an unethical and illegal contempt order that was signed by respondent's attorney Serena Baldacchino and Judge Stasio Warren November 19th of 2024 without reviewing Heather Bendl's financial affidavit and violating Heather Bendl's 5th and 14th constitutional amendments. by violating due process, Exhibit B. This raises legitimate concerns about preferential treatment and a lack of transparency in judicial actions. 7. Moreover, during a hearing on May 2nd, 2025, Mary Serlick and Ira Serlick, along with Laura Stiles, were observed waving to Judge Upchurch, indicating a level of familiarity that would lead any reasonable person to question the judge's impartiality, I cannot say that word, in this case. Ira Serlick is Volunteer and Police Services, VIPS, with the Port Orange, Florida Police Department. Number 8, Heather has an attached notarized affidavit showing the true history of events in this case, Exhibit C. These interactions and incidents collectively create an environment where a reasonable person fully informed of these circumstances would harbor a well-founded fear regarding the judge's ability to remain impartial. This undermines the public confidence in the integrity of the judicial process. Accordingly, these facts necessitate the application of Canon 3E. Now, if you're not familiar with what the canons are basically the
rules
laws,
the judges have to
follow. Right, the rules and laws the judges have to follow. So when you actually mention like penal codes and canons and Florida statutes and case law into these documents, it becomes a lot harder for them to argue anything. So I'm referencing Canon 3E of the Florida Code of Judicial Conduct, which mandates a judge's disqualification in any proceeding where their impartiality might reasonably be questioned. Judge Upchurch's continued involvement in this case violates her ethical obligation to maintain the integrity and impartiality of the judiciary, therefore warranting her recusal from the proceedings. And then arguments, it's 2.5 pages of arguments. I'm literally quoting case law, I'm quoting Florida statutes. All of this, of course, will be scanned for you guys to take a look at. I'm not going to go through all of it. And then prayer for relief. Wherefore, petitioner respectfully requests that this court, A, grant this motion for disqualification and order that Judge Sandra C. Upchurch recuse herself from presiding over this case. B, in the alternative, if disqualification is not granted, order the reassignment of the case to a different judge having no direct personal connection to Respondent Justin Serlick's family. And C, grant such other and further relief as the court deems just and proper. So this was filed May 8th. It is now May 13th, and it is still just sitting pending.
Now, if you look up the timeline that they're allowed, basically she can sit on this for 30 days. If it is not denied within 30 days, then it is deemed as affirmed. And then basically Heather would have to file a motion for a new judge, but
here's the thing, guys. I had actually quite a while ago filed a request for my 12.941D emergency custody pickup request of my children that I had filed back in December and early January. I actually requested that the chief law judge, Leah Case, look at that emergency request, and Upchurch denied my request to have the chief law judge look at it. So, this is just a circle of everyone slapping denials on everything that I do, violating every one of my constitutional rights, and clearly not caring about my children's best interests because they need help. I don't know how many times I can scream this from the mountaintops that my children need help. So that was DIN 167. 168 is just an affidavit of civil indigent status because I'm broke. And then DIN 169 I filed into my case.
That's an important thing to note for anybody out there. If you are representing yourself and you go to court and they tell you that there's all these fees you have to file, and if you don't have the money to file it, in the state of Florida, you can file for what's called indigency, where they basically don't charge you and process your paperwork.
It's really easy. But you just fill out the numbers.
You have to file this form every time you file documents with the court.
But I purposely file it every few weeks, because when this gets to appellate court, they're going to be looking at the index of my docket, and throughout the entirety of my docket, they're going to continuously see these indigent forms everywhere. a trail of indigent forms showing that I am $170,000 in debt and don't have money. But yet this same court that's waiving my fees, saying that I'm indigent, is also ordering me to pay my rapist $1,785 a month. Because that contempt order should have never happened. It was absolutely illegal. So DIN 169 is an affidavit that I filed into my case. Now, this is a little different. I have not done this previously. My attorneys had actually done something similar for me at the beginning of my motions. I did this as my own thing, mainly for the appellant court to see, and also I'm setting myself up to go up the chain of command. So if I don't get anywhere with appellant court, when it goes to Florida Supreme Court, this is a nice handy dandy affidavit timeline, background information, family history. It literally documents exactly what happened and where, and then I had it notarized. So if someone is looking at my case for the very first time, this case has been going on for 5 years now. So if they're looking at it for the very first time and they just need a snapshot of what's been going on, this affidavit is a snapshot. So it's only going to make people's lives easier as they're working their way through my appellant case. And I'm all about making it easier for everybody to help get my children the help they need. And then DIN 170 is notice of appeal for the denial of the May 2nd. So now I've got two notice of appeals, but it's merged into the same appeal. They did that for me. I didn't have to do it. Which then gives the DIN 166. When you file a notice of appeal, you have to actually put the document you're appealing, and this would be her denial on order to vacate from the May 2nd hearing. DIN 171 is actually a duplicate. I was having some weird issues with the e-file system where it was triggering a correction, and when I went to correct it, it got approved anyways. So I ended up pushing through 2 when I only meant to push through 1, but it's fine. I mean, it's notated in my docket as a duplicate. And then same thing again, 172 and 173 are duplicate indigent status forms. Or I'm sorry, 172 through 174. So they're literally all the same thing, just literally telling the state of Florida, I'm broke. And then the most recent one, DIN 175. So we are quite literally on DIN 175 since August 7th of 2023. So this is 175 documents filed into my docket. And here I am, no closer to being able to see or speak to my children, and because of the illegal activity in my case with the Serlick family and these judges. So this one, and this is the most current, this is just directions to me for the notice of appeal for the second appeal. So what I'm going to do next is a new directions to the clerk. I had already filed one directions to the clerk, so now I'm going to file a second directions to the clerk and say, now I want you to put DIN 164, because my last directions to the clerk was DIN 1 through 163. So now that I have the second thing that I'm appealing, I'm now going to do another directions to the clerk. I now want you to add in DIN 164 to 175. So appellant court has an index from DIN 1 through 175. So that's pretty much where we're at. So my May 5th hearing, motion to vacate the general magistrate's recommendations that Upchurch signed. I highly doubt she read a damn thing before she signed it. That was denied by Upchurch. That's now pushed to appellant court. Now I have a motion to disqualify Judge Sandra C. Upchurch just sitting. So we'll see what happens with that. But we're caught up. That's what's been going on.
Just as a reminder, in that magistrate's hearing that the judge just, summarily denied, we brought up evidence of Heather's son's suicide attempt in Justin's care. We brought up the grades and attendance are still a problem.
1.0 GPA.
There's significant things that were brought up that any reasonable person should be concerned about. And
any judge that cares about their job and the children they swore an oath to protect should be caring about.
Everything's just denied with no explanation. We might feel a little bit different about it if there was some sort of an explanation given. Whether it's a legal explanation or a procedural explanation, or anything, but there's nothing. There's never any information with the denials.
Yeah. So all it says is ordered in a judge that petitioner's motion to vacate the recommended order of the general magistrate and order adopting recommendations of the general magistrate is denied. The recommended order of the general magistrate and order adopting recommendations of the general magistrate remain in full force and effect. So, and this is on par with every other denial this judge has given me since she took over my case in January. There's no explanation at all. No legal basis for the denial, nothing. And they are supposed to do that.
And here's the thing, that magistrate's recommendation didn't actually end the case or close it. It's not a finality thing. What it did was basically put an end to the 3 motions that were really it was 4 motions that Heather's first attorney or her second attorney had actually filed, and basically puts us back to square one. Yeah. There's nothing stopping Heather from refiling.
No.
And going through all of this again and again and again. And that's something that
in the age of technology, where we are, us as family court corruption victims, we are connecting together across this nation, and we are sharing court documents, and we are sharing information with each other. I'm not sure what they think is going to happen here, but I'm just going to keep filing things, and I'm just going to keep chasing this until I get some sort of resolution, because how the Serlicks have manipulated the family court system in Illinois, and then using Illinois' Michael G. Nurheim behind the scenes to control the narrative down here, and them thinking that I was never going to find out about it. God, are they stupid? This really proves, without a shadow of a doubt, how much education, how important education is. Because if Mary and Ira and Justin Serlick were educated, they would know enough to know that anyone can pull these emails that we now have evidence that they were conspiring with the Volusia County Sheriff's Office. We now have evidence that they knew about this writ of bodily attachment. And if I don't know about it, they shouldn't know about it. So, they just keep giving me more and more documents to sue in court. I don't understand what their thought process is. If their thought process is, we're going to scare her away, well, they're wrong. They're not going to scare me away from fighting for my children. So, Lilium, if you need help with writing up your disqualification, I can definitely give you a copy of mine, and you can pick it apart to make it suit your needs. All of my documents, I am sharing them for several reasons. Number one, I'm sharing them because it's proof that what I'm saying is factual, and I'm not trying to lie or alter facts, unlike the other side of the case here, the respondent's side of things. And number two, I am an advocate in a nonprofit that I formed to help other victims in this situation. So if any of my documents help you with your case, by all means, share it with the masses. I'm not a lawyer. I can't give legal advice. If you want to base your legal documents off of mine, by all means, because I'm basing mine off of others as well, because we're all helping each other navigate this crazy maze that is the family court corruption in our country.
And then we'll close by just giving you this last little bit of advice if you haven't picked up on it yet in this video. Know that you have rights as a citizen. In almost every state, there's going to be, probably in every state, there are rules for public records. So there should be in your state a way for you to access records. Now, the amount of records you have access to will vary by state. We're lucky here in Florida, everything's available. So we've gotten emails to and from court officials. We've gotten emails to and from the sheriff's office. We've gotten police reports from a number of locations. But it's all, it takes time and work for you to go out and do this.
And money. It's not all of it is free. The Daytona public records requests I got, I didn't have to pay for those.
Through the Daytona Beach Police Department.
Right. But the Volusia County Sheriff's Office, I had to pay over $100 for the 2 body cams for the officers that arrested me, and then $40 for the emails and documentation. Yeah. So in total, Volusia County has made over $140 off of me just pulling these records and body cams.
How much the court records when we requested? That was like 160 almost.
Florida Circuit 7 records that gave me the email connecting Michael G. Nurheim to my then attorney Mary Jane Nettles in Florida Circuit 7, Justin's attorney and Stasia Warren. In total, that cost me over $150 through Florida Circuit 7's court administrator, Mark Weinberg. And Mark we've now figured out, Mark likes to make up different pricings for everybody. So one person will be charged $30 an hour, and then another person will be charged $35 an hour, and then the second time I pulled a public records request, it was $40 an hour. So
but then you also got a different hourly rate from the general counsel for Circuit 7.
Right. So everybody's just making up their own.
It's all over the place, and
it
just makes you think, okay, these people are just being completely sketch, and something is not right in the background.
Know your constitutional rights. Get involved with the movements. I'm going to continue to advocate for, if you are just starting this process of fighting this illegal activity in our family court system, connect yourself with others that have been through it so you don't feel so alone. Because I'm telling you, if I was connected to everybody that I'm connected with now 5 years ago, I would have had my children back a long time ago, because I would have had the courage to finally start speaking up in regards to my case sooner. So many of us are scared with these gag orders and the threats and the power that they hold over us by using our children as weapons. People are scared to use their voice, and all I can say is surround yourself with support. I am involved in these 3 movements. I will be doing a writ of habeas corpus in Illinois for multiple of my liberties violated. I will be doing my writ of habeas corpus here in Florida for these illegal violations of my liberties. I have done my 5-minute video for the Dave Weigel project, for the Family Court Warrior Project, where all of those 5-minute videos are going to be stitched together to make a documentary. I am also turning in my affidavit to Tanawah Downing on his tour across the nation. There is going to be a nationwide protest, peaceful protest on June 8th, Sunday, June 8th, on National Children's Day. Get involved in that in your state. There are a lot of different movements raising awareness to what these positions of power are doing to our children and doing to us. And all I can say at this point is advocate, advocate, advocate for yourself. No one is going to advocate for you more than yourself. No one is going to advocate for your children more than yourself. And there's one thing that my children will never be able to say, is that I did not fight for them. I will fight for them until the day I die. And I'm never going to give anyone an opportunity to say that I did not fight for them. So Everyone's caught up in my family court case and the appellant court case. The appellant case is still in that pending status where Circuit 7 has to put together the, what's the word I'm looking for? Index. They have to put together the index and then send it over to appellant court, and then we'll start getting dates for that. And then I have to file my briefing, and then Justin has to file his response to the briefing.
Well, he doesn't have to file.
No, he doesn't have to. We'll see what they come up with. But he will have to, otherwise it's not going to look good for him. So appellant court is a lot stricter than the lower tribunals. There is a whole process that we have to go through, and you have to stick to that process.
It's very procedural. So.
Yep. Which is fine by me, because I've been wanting things to be procedural for the last 5 years, and it's been dictated by the Serlick family the last 5 years. So here's me controlling the narrative.
With that, thank you for watching. I'm going to cut Heather off, otherwise she will keep talking all night. And
educate. You got to educate people.
Right.
But anyways, I really appreciate everyone's support. I really appreciate everyone's knowledge and strength that they're giving me. It gives me strength, and that allows me to pass my strength along to others that are needing that strength as well. So I really appreciate all of you, and thank you for listening. Have a great night, everyone. Bye-bye.
Take care.